This is correct.
Support matter underground.
So,
Getting admission, serial number 26, MA number 140 of 60. Alok for appellate, Mr. Malov Prasad, Mr. Anjali Kumar for respondent.
Yes, Your Lordship, in this case, this is a case we are challenging the liability on the ground of invalidity of the driving license. In this case, we have filed an application under Order 41 to 27, subject to correction, my lord. On the last occasion, the respondents they have paid for time for filing a rejoinder to my application under Order 41 to 27 because we had taken a defense of driving license, but with the help of the District Legal Services Authority, who we could get the access and the detail of the driving license that would be annexures in the Order 41 Rule 27, and it was found that driving license was fake. And
No,
the
no.
learned friend,
Have you satisfied the amounts? They
my lord,
were.
in this case, let me check it up, my lord. Yes, in terms of order dated 22nd of April 2016, some order
Who
was
are the
passed
claimants? Who
with
are the
regard to the
claimants?
depositing of the amount.
Who are the claimants in this case?
Number of claimants are there, my lord. The number of
Is a
package
name.
of counsels are there, my lord.
Mr.
I do
Anjali
not know
Kumar.
whom they are representing, who is representing whom.
Rejoinder not filed.
Yes,
Where is your
record
ID?
was also called for perhaps. On 15/10/2019, the record was also called for.
No, no, no. What is the driving license number?
Yes, driving license number, your lordship, as and on the last occasion, but I would like to proceed one thing, my lord. The very conveniently, the claimants they have submitted that we have not deposited the amount. Now, I have filed a receipt showing that this amount has been deposited and they have also received the check also. 25/5/2016 is the endorsement of receiving the check. I filed a receipt thereof. They have they have taken the amount.
What is the license number which
One of the license
was
number as per the report of the Annexure 2/1, particulars of DL number 35757 slash F slash 207, the DL number 353757 slash F slash 207, professional Chaibasa of Chaibasa.
no, this is work in progress.
Yes, Your Lordship.
This is work in progress. What does it mean?
No, but thereafter, the Annexure 2/1 may kindly be seen. After that, the 2/1 may kindly be seen.
Yes.
2/1, 2 is the verification report. 2 is the verification report, which suggests that last paragraph, the investigator's opinion, in my opinion, Mohammed Salim, DL number such and such, not renewed on 26/10/2000, 10 to 15/6/2007, and
On
was
what
not valid.
basis?
It was not valid on the date of accident.
On what basis?
Yes, Lord, on the basis of Annexure 2/1.
No. What is 2 by 1? Read. On what basis?
2/1 is by a annexure 2/1 to the petition to the subsidy, the petition on order 41 to 27, in the last page of the brief. On
On
the
what
date of
basis he is
accident, the
writing
license was not
this?
valid.
On what basis he is writing this? This cannot be taken in evidence.
Well, that is on the basis of the annexure 2/1 given by the certificate given by the district transport officer, West Sibul
Where, where,
Chaibasa.
where is the certificate? Sure, tell me.
That is 2/1.
Yes.
Memo number 75 dated 15/3/2016.
Yes.
So on that basis, the surveyor has given a report that this driving license was not valid. We were diligently asking for the concerned licensing authority to supply the
This is not an
details.
original document. This cannot be taken in evidence.
It's not. Is it not there?
No, no, this cannot be taken in evidence of type copy, computer type copy. You don't know who has signed it and what is this. What prevented you from bringing this document before the court below, before the tribunal?
It prevented me because when the case was pending, we had made a request to the licensing authority to issue the certificate, which they were not issuing. We also moved the district legal service authority. Then, by their good officers, the officers of the district transport officer came into came into action. On not only this, kindly see the other page, because several, not only this case but in several cases the license ki verification was asked for. Kindly see annexure 1 by 1, page 9 of my petition under order 40 rule 27. This was a letter addressed to the district secretary legal district legal service authority. Now thereafter on page 10, they have given the details of the cases of the driving license which were pending before them. Now, so far, item number 8 is concerned at page 11, work in progress. So, this was the reason we prevented from getting the driving license renewed, verified. When the case was pending, we had been diligently prosecuted, asking the district transport authority to supply me the details of the driving license.
Date of accident.
The date of accident is The date of accident is 22nd November 2010, and as per this report, the page 13 of my petition, this driving license was earlier it was issued, but it was not renewed on that date of accident. Last renewal was on 15/6/2011.
What is the vehicle? What is the vehicle?
What is the
What is the vehicle involved in the accident?
what is the reason?
What is the vehicle? What is the vehicle which was involved in the accident?
Now the basis is the
What is the
basis
vehicle? What is the vehicle which was involved in the accident?
the vehicle involved in the accident was Scorpio.
LMV,
Yes.
light motor vehicle.
Well, there is some issue with regard to the audio from your lordship's end, because
So,
audio is not very clear and not loud.
so the license was not valid for 6 months.
No, license, Malad, the issue is valid and effective driving license. It was not effective on the date of accident. The driving license, once it's expired, it remains valid. If it is renewed within the 30 periods of validity, 30 days, then it shall be deemed to have been renewed on that day. But here, the renewal is on what date? This was not renewed after that. Had it been renewed within the 30 days of its last expiry, the matter would have been different. But on the date of accident, very accident, there was no renewal, nothing, no license was there. So the question is the valid, not only valid, but effective driving license. So this driving
Who is,
license,
who is for the owner? Owner has not appeared.
there are a battery of lawyers, Your Worship, they are appearing, but I do not know who is representing. But on the last occasion, they had prayed for time to filing the rejoinder to my petition.
Where is Mr. Jitendra Tripathi?
Madhav Prasad, Anjani Kumar, Rajesh Kumar,
Someone
Kanti
is
Kumar,
appearing in the first
Jitendra.
half. Someone is appearing in the first half. Mr. Tripathi was there in the first half when the matter was called out. Look at the second round when the matter was called out. The counsel appearing on behalf of the respondent is not present. First up, let's this case on 10th. Physical day court. Now, let's this case on 12th. 12th.
Serial number 27, MA number 243 of 60. Serial number 4
Yes, Mr. Mr. Aman?
Your Lordship, in the instant case, I am appearing on behalf of the petitioner.
Yes.
And this MA has been filed for enhancement, Your Lordship. Liability is of upon insurance company.
Not no recovery granted.
No, Your Lordship. Although that has been prayed in the court below, but that has not been granted.
On what ground you are praying for enhancements?
Deceased was a student of BSc IT, Your Lordship. His income has been considered as 3,000 per month. Future prospect has also not been given. And on
Yes.
conventional head, only 2,500 has been given.
Which company? United India.
In
Which one United India?
Manish, Mr. Manish is also appearing on behalf of.
Manish Kumar. Mr. Manish, you are.
My lords,
Mr. Manish, this can be resolved in Lok Adalat, I think.
let him serve the copy to me, my lords, and let it come on 12th.
By tomorrow, I'll serve, Your Lordship.
Yes.
Yes.
List this case on 12th to explore whether there's a possibility for settlement of the dispute amicably. On your interest, you have to serve a copy to Mr. Manish.
Your Lordship, by tomorrow itself, Your Lordship. Oblige, Lordship.
Orders.
Serial number 30, MA number 561 of 16, Mr. Manish Kumar for appellant, Mr. Namit Sahib, Mr. R. Verma, Mr. P. N. Patel, Mr. Saurabh Shekhar for respondent.
My lords, in this case, the ground for appeal is that the driving license was not proper, my lords, and it was not filed despite the owner had appeared and filed his written statement. On the last date, the copy of written statement was not in the record, so my lords were pleased to direct the learned court below to send original LCR, my lords. So I am praying it may kind of listed on Monday so that it can be verified, my lords.
Monday,
Your Lordship, appearance for respondent 2 and 3.
come ready on Monday.
Oblige, Your Lordship.
Mr. Manish, just a minute.
My lord.
Let it be on days. Tomorrow?
Yes, let it be tomorrow. Yes, my lords.
Tomorrow.
Yes.
Oblige, Your Lordship.
Tomorrow. On the request, is this case tomorrow?
Regular cases, serial number 35, MA number 677 of 17, Mr. Sudhir Sahib, Mr. Mitul Kumar for appellant, Mr. Manish Kumar for respondent.
Make up lordship. Not in this case, not the award has been passed against the appellant. 40% has to be paid by the appellant on the ground that the deceased was traveling on the rooftop on the request of the. Only my submission will
40% apportionment liability apportioned upon you.
yes, ma'am. And 60% on the insurance.
So you are the.
And the owner, Milord.
How are you agreed?
Milord?
How
Milord,
are you agreed?
I am agreed only to that extent, Milord, that the deceased was traveling on the rooftop, and the decision and the impugn order says, Milord, that he had gone to on the rooftop on the request of the Khalasi. Khalasi has not been made party in this case, Milord, before the lower court, Milord. My submission, Your Lordship, is this, that Your Lordship is aware of a full bench judgment of this honorable court, and the Supreme Court judgment.
Supreme Court judgment?
And the Supreme Court judgment has not decided the issue, Milord. I read the Supreme Court judgment.
Yes.
It has only said, I may read.
Pay and recover.
Milord,
Pay and recover. It says pay and recover.
I recover in this case. But the ratio has not been decided as far as the Supreme Court judgment is.
So that same judgment has gone, this full bench judgment has gone before the Honorable Supreme Court, and the Honorable Supreme Court has said pay and recover. In that case.
Therefore, Milord,
Therefore,
The Supreme Court judgment has to be considered, my lords.
yes, pay and recover.
My lord, I pray for not today, let it be tomorrow, my lords. I have taken instruction to file cross appeal. I'll inform you lordship tomorrow, my lords, what is to be done.
Then it will come
Only
on
not
Monday.
today, I'll praying, my lords.
After vacation कर दिया जाए जो.
My case has been called in another court, my lord, so I was taking.
Mr. Sahai,
Yes, my lord. छुट्टी के बाद रख दिया जाए, उनका क्रॉस अपील आएगा, हम जवाब देंगे.
just listen to me. Now your liability is 40%.
Yes, my lord.
By challenging it, you will enhance your liability to 100%.
As your lordship directs me, I'll abide by
Why
it.
should I direct? Admittedly, rooftop passenger. The tribunal has only directed you to pay 40%. You should have been happy with that 40%. And now you have given a liberty to the insurance company to file a cross objection. Because this appeal is pending. Their cross objection will be maintainable and will be within time also. Though their independent appeal would not happen within time.
Yes, my lord, your lordship is correct.
So now this 40% will be increased to 60%. Pay the amount.
My lord?
Satisfy the amount.
All right, my lord. I'm satisfied.
On the request of the parties, this case is adjourned for tomorrow or after vacation? After vacation.
After vacation.
Next part. It is made clear that in the meantime, the award should be satisfied and a report should be sent to this court by both the parties. Pay 40%.
Yes, my lord.
Serial number 36, MA number 734 of 70, Mr. Alok Lal, for opponent, Mr.
Just take down Mr. Manish Kumar. इसका आगे वाला केस में let name of Mr. Manish Kumar appear in the cause list. इसका आगे वाला केस. कौन केस था?
In this case, which has just been called for,
Yes.
there is nothing in this case save and except kindly come to paragraph 47 of the award.
Withdraw it.
No. Nothing. Simply the quantum assessment. Kindly see the non-pecuniary head.
No. Mr. Lal, you have right to raise this case before the Lok Adalat.
Well, I'll have to seek instruction, but the kindly see this is the thing only that is something wrong. And in this case, we have deposited rupees 7,28,000 along with the interest at the rate of 9%. So the entire awarded amount has been satisfied.
So the award has been satisfied.
Yes.
So you don't want to challenge.
Yes.
You are not challenging.
No, I am challenging the quantum. This paragraph 47.
What is paragraph 47?
Paragraph 47 may kindly be seen.
Paragraph 47. This. Okay.
Yes, 47 at page number 26. Funeral expenses 25,000. Loss of love and affection to parents 1 lakh. Loss of love and affection to children 1 lakh.
4,25,000. Yes, Mr.
4,25,000.
Counsel. Mr. Counsel, Mr. Mishra, who is appearing?
Your Lordship, I am appearing for the claimants, Your Lordship.
Yes.
Your Lordship, I would like to point out just one thing, Your Lordship, that nothing has been paid under the heading for future prospects, Your Lordship.
Nothing has been paid on the account of future prospect.
Yes, Your Lordship. Paragraph 46 is the calculation, Your Lordship.
Even if the future prospect is added, the amount would be around 10,28,000.
Yes, Your Lordship.
Are you agreeing with 10,28,000?
I am, Your Lordship.
You are agreeing?
Yes, Your Lordship.
Let me calculate. Let me calculate the amount. What it is the 5,000.
50,000 we have already paid under no fault liability.
1/4 reduction, na?
No, that is indicated in the paragraph 48 also.
Like 20. What is the age of the deceased? When was it?
36.
There is no error in that part, my lord. It is 36 years. 36 years.
36.
Yes.
So 40%.
Yes, Your Lordship.
Yes. 40% on this thing we have that comes to 2,88,000. That adds up to, because that makes 7,20,000 makes to
10
10
lakh
lakh.
8,000. 10 lakh
10 lakh.
8,000 plus 70.
Yes. I'm not touching the monthly income also, not the multiplier. If future prospect is added,
So Mr. Alok Lal, are you agreeable for 10 lakhs 50,000 already paid?
no, but 7,20,000 we have deposited as per the order by your lordship.
Just a
22nd.
minute. Listen to me. Are you agreeable for 10 lakh 78,000 plus interest?
Well, that would be that would be the appropriate amount minus 50,000. Minus 50,000 that we have paid under no.
Just a minute. Are you agreeable for 10 lakh 78,000 plus interest less the amount paid? 50,000 less 50,000 and
May I
withdraw
interrupt you? May I
withdraw
interrupt your lordship? My lord, may I
withdraw
interrupt for a moment, your lordship? May I interrupt for a moment? In the terms of order dated 27/9/2019, we have deposited 7,29,000. Now, just a minute. With interest calculated on that amount? With interest calculated on that amount?
which amount?
On 7,28,000. That amount has been deposited with interest. That is what I am pointing out.
No. How 7 lakh 28,000?
Because 27/9/2000, because the this honorable court was pleased to issue notice and the stay was granted subject to that order.
Mr. Alok Lal, you take back this amount which you have deposited.
No, I cannot dispute with regard to 10,78,000. I cannot dispute with regard to that. That would be appropriate amount.
10 lakh 8,000
10,08,000. That would
plus
be appropriate.
interest. Plus interest.
But the interest would be on only this amount which is remaining.
No, you take the entire amount. You take back your entire amount.
The entire amount we have paid, deposited within.
You paid, you have deposited. You take refund of that entire amount.
Then who will refund your lordship? The claimant, that this may be directed upon the claimant to refund the amount.
Claimant has not taken the amount. Claimant has not taken the amount. Have you taken the amount, madam?
No, Your Lordship. It was deposited before.
It is deposited.
There was an order. There was an order to be disbursement. If they are not taking their out, how we are concerned about it? There was specific order for disbursement. There was the order for disbursement also.
Your
They
Lordship,
have chosen not to withdraw the amount. Very cleverly.
After due notice, whether notice was sent to them or not, I don't know.
Notice was issued on 27/9/2019 itself.
No, Mr. Lal, this order was that after due notice to the claimants that withdrawal. You calculate the with interest 10 lakh 8,000. What will be the interest?
Just a minute. I'll have to calculate. That will take time. Let it come on some other day. I'll calculate and let him.
Calculate and let this court know. On 12th?
On 12. But the thing is that the rate of interest also. Rate of interest is also very high. 9%.
We will see to it. Calculate on 9%.
Okay, sir.
Now, but they will clarify on that day whether they have received the amount or not. They should also
Yes,
come to the stage.
You also clarify whether you have withdrawn the amount or not.
Yes, Your Lordship.
They will also submit on that day.
Yes. On 12th.
Okay, Your Lordship.
Yes, 12th. I'm ready for orders.
Serial number 37, MN number 127 of 20 Mr. Manish Kumar for appellant, Mr. Anil Kumar Ganju, Mr. Sarvendra Kumar for respondent.
May I please, my lords, in this case, there is, my lords, although we have challenged so many things, my lord, but the issue is quantum only. And second issue is that, my lords, there was a contributory negligence and two vehicles were involved, but, my lords, the insurer and owner of the other vehicle was not included as party. But, my lords, I will say at the outset, my lords, those grounds cannot be pressed, my lord. The only ground now left is rate of interest, which is 9%, because this is a case of death of housewife, and we have taken a plea that income should have been assessed at 3,000.
Death of housewife interest should be 12%.
No, no, what that is correct, my lords. What I am saying is what
What
I
is
can.
what are you trying to say? Death of housewife, no interest, we will give no interest.
No.
Then
I am saying that death of a housewife, and we are taking a plea that 3,000 should be proper, should have been taken, and all these things I am not pressing therefore.
absolutely.
So left
Personal
with no alternative.
Personal income. See,
My lords,
Your Lordship,
what I
I'm
personally feel, the notional income for a housewife at the rate of 3,000 is on the much lower side.
I am not pressing those points, my lords. I am saying that these are
What
the
a
grounds.
housewife puts in the family, and to maintain the equilibrium of the entire family, it's much more than 3,000. So, Mr. Counsel,
My lords, it has been taken at a lower side. I will humbly say, my lords.
should be
Only
at
ground-
least. What is the claimant? Claimant is the husband.
Claimant is the husband and children.
What is the claimant? What is the claimant doing?
Claimant is, my lords, it is not clear, my lords. There is a judgment of Honorable Supreme Court which says that half salary of the husband should be taken as income of the housewife.
Why half?
That is the judgment of Honorable Supreme
Why not
Court.
75%?
Therefore, I said only ground is interest, my lord. So I am not arguing this case. Therefore, my lord should not take umbrage to that.
12%.
No, let it be there, my lord. It can be dismissed easily. I am not saying anything. What I am saying, the only thing which I can say is that 9%.
I am referring this case to the Lok Adalat.
Yes.
Tell your officer that to submit on that date with folded hands, that this is the check which I have brought.
Yes, my lord. Yes. Definitely.
This matter, there's a chance of settlement. There's this case, the Lok Adalat. Who is appearing for the opposite party?
Your Lordship, I am appearing for the respondent number 126.
Who are respondent 1 to 6?
They are the claimants, my lords.
Tell your respondent number 1 to appear, come on 14th, Lok Adalat. Be there.
Oh, bless.
Mr. Manish Kumar will ensure that their officer will come with the check. Or
Yes.
at least you tell, madam, you tell your client to come with a passbook and a cancelled blank check, your Aadhaar card and PAN card. Or PAN card.
Okay, Your Honor. Oh, blessed.
Obliged.
Yes.
Clear number 38, MA number 154 already, Mr. Amresh Kumar for appellant, Mr. Subodh Kumar Dubey, Mr. Mukesh Kumar Dubey for respondent.
My lord, I am appearing on behalf of only respondent number 4, my lord.
Where is Mr. Amresh Kumar? What is the ground? What is the ground taken in this appeal by the insurance company? Yes, where is Mr. Amresh Kumar? What is the ground in this appeal, Mr. Dubey? What are the grounds taken?
My lord,
somebody in this case? Hit and run. This is a case of hit and run.
My lord, pardon, pardon me.
This is a case of hit and run.
My lord, it is a case of accident. My client's motorcycle driven by his full brother, my lord.
Where is the appellant? Yes, Mr. Amresh.
Yes, yes, Your Lordship.
What is your you are taking a plea that this is a case of hit and run?
Yes, Your Lordship.
How?
And the disease was not the owner of the motorcycle. Your Lordship. At that time, Your Lordship, this is not the personal accident, Your Lordship. It is also taken, Your Lordship.
So who was the deceased?
Disease is the brother of the owner, Your Lordship. In the MV Act, Your Lordship, honor is defined.
Yes.
Your Lordship, in the MV Act, Your Lordship, in section 2, Your Lordship, in 30, honor. Honor means a person in whose name a motor vehicle stands registered, and where such person is a minor, the guardian of the such minor, and in the relation to a motor vehicle which is the subject of a hire purchase agreement or an agreement of a lease or an agreement of hypothecation, the person in possession of the vehicle under the agreement. That he is the brother of, and he is not the borrower of the motorcycle. He is not the owner of the
He is the borrower of the motorcycle.
Yes, yes.
Court records. Call for the lower court records.
Obliged.
Under the heading for hearing, serial number 39, MA number 95 of 50, Mr. DC Ghosh for appellant, Mr. Nikhil Ranjan for respondent.
Lordship, on the last date, Mr. DC Ghosh has asked for time for a week to seek instructions from his insurance company regarding the withdrawal of the case on his part.
Where is he? Together, Mr. DC Ghosh is absent. Is this case on Monday? Monday.
Much obliged, Lordship.
You are appearing on behalf of
Mr. Nikhil Ranjan, the
claimant.
claimant. Yes, Your Lordship.
Serial number 40, MA number 45 of 16, Mr. Chandradeep Mukherjee for appellant, Mr. Alok Lal, Ms. Savita Kumari, Mr. D.K. Bandya for respondent.
Your Lordship, here I am appearing on behalf of the claimant appellant in this matter, Your Lordship, for enhancement.
Yes.
The case is of injury, Your Lordship. The claimant's right leg has been imputed above the knee and 75 right leg above the knee.
What was his profession?
He was a student, Your Lordship, of Xavier's College.
Aged about?
18 years. And he was a pillion rider. He was going along with his friends. Though, admittedly, it is a triple riding case, Your Lordship. However, court has come to the finding that there was no contributory negligence of this claimant, Your Lordship. and detailed observation has been given by the learned court below. And Your Lordship, coming to the quantum part, Your Lordship, that has been discussed in internal page 14, running page number 39, Your Lordship. Notional income has been considered to be 1,500.
Yes, Mr. Lal. Who is appearing?
Mr. H.K. Singh will be arguing the matter because
Singh?
For the
Mr. Singh.
insurance company, I am appearing, my lord. This is a case of res ispa locutor, head-on collision between the two vehicles. Now we have to see that which of the vehicle was wrong, and the motorcycle which was running with three persons had no driving license. The person who was driving had no driving license, and he dashed with a minibus. And most part of this, the petitioner has got 6,67,755 rupees as full and final settlement. Again, he has come here. We have given because he was the faulty. I was not the faulty. Bus was not faulty because he was driving the motorcycle with three persons.
Mr. Singh, this is which company? This is which company?
This is the New India Insurance Company.
Tell your officer to be present in the Lok Adalat. Tell your officer to be present in the Lok Adalat. This matter can be resolved in the Lok Adalat.
We shall try, my lord, but we have already given all these things.
No. 6
Your
lakhs is
Lordship, very meager amount has been given, Your Lordship, because
6 lakhs.
even CW3,
it is
1,500 rupiah notional income has been considered, Your Lordship, which may be 75% disability ke hisab se it comes to 1,300 something.
where the claimant has paid for enhancement of the compensation amounts.
This is for the United India Insurance Company.
This court feels that the matter can be resolved with the Lok Adalat. Thus, this matter is referred to the National Lok Adalat, full stop. The officer of United India Insurance Company Limited and the New India a competent officer of United India Insurance Company Limited should remain present in Lok Adalat, to be National Lok Adalat, to be held in the premises of Jharkhand High Court on 14th May.
May I submit just one thing, Your Lordship? If any settlement amount they come forward with, I'll convey to my client, and at least on that issue, on that particular day, they will come prepared.
One representative of your client will be present there in the Lok Adalat also. Can be decided there itself.
Lordship.
Serial number 41, MA number 183 of 60, Mr. Alok Lal for appellant, Mr. Sumit Kalodia, Mr. Akshay Kumar Mahto, Ms. Anya, Mr. Subham Mishra for responding.
But in this case, I am challenging the liability as well as the quantum.
Liability how?
Liability of the insurance company on two counts. Firstly, the extent of coverage of the policy, number one. Number two, on the point of validity of the driving license. And thirdly, on the point of quantum, that is, mother is the claimant. Instead of 1/3, 50% has been, the third 1/3, 50%, 1/3 has been awarded. Now, let us, subject, if my learned adversaries are there, I will begin, Your Lordship. Now, let us come to.
Is your adversary?
I am for the claimant, my lord. For claimant, I am appearing.
Who is for the owner?
Owner.
Who is for the owner?
My lord. From the office of.
Lordship, 41 has been followed, Lord.
Yes.
Yes, Your Lordship. I am appealing for the owner, Lord.
Yes.
Now in this case,
yes,
let us go through the judgment, Your Lordship. In this case, the claimant has claimed that उसका बड़ा लड़का ज्योति प्रकाश महतो उम्र करीब 22 वर्ष थी, जो बीकेबी कंपनी ट्रांसपोर्ट डंपर टिपर में के नंबर JH9J2510 में खलासी के रूप में कार्य करता था। उक्त डंपर ट्रिपर गाड़ी संख्या JH9J2510 बीटीपी एस के थाना अंतर्गत एस पॉन्ड छाई उठाने का काम करता था। मतलब दिस थिंग where it was located is very important. I would demonstrate how it is not covered, how we are not liable. छाई उठाने का काम करता था। यह कि दिनांक 25/7/2011 को डंपर संख्या JH9J2510 छाई उठाने के लिए एस पॉइंट गया हुआ था तथा छाई उठाने के लिए कतार में गाड़ी खड़ी होने के बाद नीचे अपना गाड़ी JH9J2510 के उतरकर पीछे तथा करीब 6-7 बजे के बीच डंपर गाड़ी नंबर JH13702 का चालक द्वारा गाड़ी को बैक करने के दौरान गाड़ी संख्या JHW3702 का चक्का उसके बेटे ज्योति प्रकाश महतो के कमर के ऊपर चढ़ गया। वह बुरी तरह से जख्मी हो गया। उसे तत्काल बीकेबी ट्रांसपोर्ट कंपनी इलाज के लिए बीजीएच ले जाया गया और 10 बजे उस लड़के की भर्ती कराया गया। इलाज चल रहा था। इलाज के दौरान 25/7/11 को करीब 3 बजे उसके बेटे ज्योति प्रकाश की बीजीएच में मृत्यु हो गई। Now, in this case, let us come to paragraph 2. The owner and driver they have appeared. अभिलेख का अवलोकन करने से स्पष्ट होता है कि न्यायालय द्वारा निर्गत समन के आधार पर विपक्षी संख्या 1 एवं 2 क्रमशः गाड़ी का मालिक तथा चालक न्यायालय में उपस्थित होकर अपना अधिवक्ता के माध्यम से दिनांक 30/4/2012 को न्यायालय में अपना लिखित जवाब दिए हैं। इसी प्रकार विपक्षी संख्या 3 यूनाइटेड इंडिया बीमा कंपनी लिमिटेड न्यायालय में उपस्थित होकर अपना अधिवक्ता के माध्यम से दिनांक 12/4/13 को न्यायालय में अपना लिखित जवाब दिए हैं। विपक्षी संख्या 1 एवं 2 चालक वाहन टिपर JH संख्या W3702 का क्रमशः मालिक एवं चालक की ओर से दिनांक 30/4/12 को लिखित बयान दाखिल करके यह कहा गया है कि आवेदक दाखिल करने का संदर्भ नहीं है और खारिज होने योग्य है। यह कि लिखित बयान में की कंडिका 5 में वर्णित है कि आवेदकगण की ओर से उस मोटर अधिनियम 166 और 140 के अंतर्गत दाखिल आवेदन संधार्य नहीं है और खारिज होने योग्य है। यह कि उस लिखित बयान में कंडिका 6 में वर्णित है कि विपक्षी संख्या 1 का टिपर वाहन पंजीयन संख्या JH01W3702 का मालिक और विपक्ष संख्या 2 गेंदू गिरी उस ड्राइवर का चालक है। यह लिखित बयान में कंडिका 6 में वर्णित है तथा कथाकथित डंपर वाहन पंजीयन संख्या सच एंड सच तथाकथित यूनाइटेड इंडिया बीमा कंपनी लिमिटेड के हेड ऑफिस 24 व्हाइट हाउस चेन्नई डिविजनल मैनेजर बोकारो 4A17 प्रथम तला से इतना देखिए उसकी वैधता की तिथि 8/7/11 से दिनांक 7/7/12 तक है। यह की विपक्षी संख्या दीज आर देयर क्लेम। नाउ in this case, now let us come to the written statement filed by us. That is from in the same paragraph. But then I'll read मतलब ब्रेकअप कहीं नहीं इसलिए पता नहीं चल पा रहा है। विपक्षी संख्या 3 की ओर से दिनांक 3 इज इंश्योरेंस कंपनी 3 की ओर से 12/4/13 को अपना लिखित बयान न्यायालय में दाखिल किया गया। निवेदन के साथ कहा गया है कि दावाकर्ता विपक्ष संख्या 2 द्वारा मृतक पिता इस बात में दावाकर्ता संख्या 3-4 को अनावश्यक रूप से पक्षकार बनाया गया है। यह कि दावाकर्ता 3, 4 और 5 क्षतिपूर्ति के हकदार नहीं है क्योंकि मृतक अविवाहित था। यह कि लिखित बयान से कंडिका 10 में वर्णित है कि घातक वाहन टिपर संख्या JHW3702 बीमाकृत वाहन है जिसका बीमा संख्या पॉलिसी इतना है जिसकी वैधता तिथि 8/7/11 से 7/7/12 तक है। यह की लिखित कंडिका बयान के 14 में वर्णित है कि दावा आवेदक में वर्णित बात की मृतक ज्योति प्रकाश महतो 4,500 रुपये 500 प्रति महीना पाता था गलत है, जबकि वास्तविकता यह है कि खलासी के रूप में 100 रुपये दैनिक मजदूरी मिलती है। उसे एक दिन के बाद दूसरी दिन मजदूरी मिलती थी। यह कि मृतक प्रत्येक महीना 1,500 रुपये से ज्यादा नहीं कमाता था। यह दावा करता मृतक आमदनी के बारे में कोई ठोस प्रमाण न्यायालय में नहीं दिया गया, समक्ष नहीं दाखिल किया है। यह लिखित बयान की कंडिका 15 में वर्णित है कि दावा आवेदन कंडिका 12 में वर्णित आधारहीन, बनावटी, अनुचित, बढ़ा चढ़ा कर कही गई है, इसे विपक्षी संख्या 3 अस्वीकार करता है। दावाकर्ता का इस बात को साबित करने की आवश्यकता है। यह लिखित दावायान में पट्टिका 16 में वर्णित है। विपक्षी संख्या 3 बीमा अधिनियम धारा 64 बीवी और मोटर अधिनियम धारा 147, 148, 149, 2, 160, 170 और 173 के वर्णित प्रावधानों के अंतर्गत सुरक्षा पाने के अधिकारी हैं। यह कि बीमा विपक्षी संख्या 3 की ओर से दाखिल जवाब में स्वीकृत करने का दावा किया। यह विपक्षी संख्या की ओर से आवेदक गण की ओर से दिनांक 26/11/11 का दावा आवेदन को खारिज करने योग्य है। नाउ 6 issues were framed. Issue number 4 was pertaining to the driving license. Now, I would like your lordships to travel to page number, paragraph
Where the court deals with issue number 4.
Yes, that is what I am pointing out, your lordship. So far,
Para 10.
yes,
Para 10.
Para 10 may kindly be seen.
No, sorry.
No,
Para
not
10
para
is
10.
not
Not
para
para
10.
10. Not para 10.
Para 10 is discussion of VW4.
So far, I have not been able to find that this issue, which was cast by the court, has been discussed. This issue has not been discussed so far, and no, it has not been decided. So, unless this issue with regard to driving license and a permit, though the issue was framed, is decided, in this case, we have adduced certain evidence. We have adduced certain evidence. Now, paragraph 11 may kindly be seen, that is my evidence. Discussion with regard to my evidence. इस वाद में विपक्षी संख्या 3 बीमा कंपनी की ओर से अपने बचाव में एक साक्षी सत्येंद्र कुमार का साक्ष्य कराया है। इस साक्षी ने न्यायालय में दाखिल होकर मुख्य परीक्षण खंडिका 1 में कहा है कि यूनाइटेड इंडिया इंश्योरेंस कंपनी को गवाही देने में प्राकृत किया गया है। इस साक्षी ने अपने मुख्य परीक्षा के पंडिका 2 में कहा कि डंपर टिपर वाहन संख्या संच बीमा की पॉलिसी हेतु यूनाइटेड इंडिया कंपनी से दिनांक 7/8/11 से 7/7/12 तक बीमित थी, तो अंतर्गत नियमों एवं शर्तों के साथ की गई थी। यह कि बीमा पॉलिसी के पृष्ठ संख्या 9 IMT 13 में शीर्षक यूज ऑफ व्हीकल इन इंश्योर्ड ओन प्रेमिसेस। नाउ my lord, kindly come to the policy, which is exhibit.
Just a minute.
Yes, the policy was exhibited.
Yes.
Kindly come to page 9 of the policy, the IMT 13.
Yes.
Use of vehicle within the insured's own premises. It is hereby understood and agreed that the insurer shall not be liable in respect of the vehicle insured while the vehicle is being used elsewhere in the insured premises, except where the vehicle specifically required for mission to fight fire. For the purpose of this endorsement, use confined to own premises shall mean that only use insured premises which public has no general access. This was a specific exclusion with regard to the use of vehicle any place outside the scope of the insured premises. Now, this was a fund of BCCL wherever it was being used. So, therefore, outside the scope of liability coverage. This is the one submission.
What is your evidence to that effect?
It is their admitted part because it was in the chai collect करने pond में गए हुए थे. It is their case itself. So, something which they are admitting. Why should I produce an evidence? Why should I cross-examine that?
Where are they admitting? What have you brought any evidence that where the accident has taken place?
The evidence, their claim application itself shows they have claimants they have themselves examined.
What they have
Yes,
said. What they have
yes,
said.
yes, yes. Now, there it is their evidence. So, is there any necessity of adducing any evidence when things we are admitting it?
Absolutely. Where is the Khatiyan to show that the land belongs to BCCL? Where the accident had taken place?
Or that it should not be in a hyper technical and super technical manner,
No, no,
because
no. This is not neither hyper technical, not super technical.
no. But the thing is that
Your plea is that it was not in the premises of so and so. You are taking this plea, so you have to prove it.
but in this case, their evidence, their
One day I
claimant.
have to clear it tomorrow. Tomorrow. Heard in part tomorrow. Physical way.
Obliged.
Obliged, my lord.
So far as license is concerned, I can understand if there is anything. So far as you are taking an hyper technical group, the premises. So far as license is concerned, I can understand whether he has decided or not decided. Hard in part further tomorrow.
Obliged, my lord.
Serial number 42, MN number 305 or 16, Mr. DC Gold for appellant.
Where is Mr. Ghosh? Mr. Aloklal? He is missing.
Malad, he was going outside Ranchi for some time. For a week, perhaps he has told me that he will not be here. So I thought he must be busy in some of his friend's marriage, friend's daughter's marriage. This is what he has told me. He'll be having some difficulties from second onwards. I thought that must be because of his friend's daughter's marriage.
This case is also he is not there. Keep it on 12th. No one appears on behalf of Mr. DC Ghosh on behalf of the appellants. They discuss on 12th.
But then this case, let this matter come up after the summer vacation. The item number 41.
41? No. Tomorrow. There's no complex issue in it. It can be easily decided.
After summer vacation, कर दीजिए.
Tomorrow, part further tomorrow. वही वाला. 41.
Serial number 43, MN number 545 or 16, Mr. Vikas Sinha for appellant, Mr. Gautam Kumar, Mr. Sandeep Kumar Bandawal, Mr. Puri Kumari, Mr. DC Mishra for respondent.
I am appearing my lord, respondent number 5, my lord.
Where is the appellant?
Mother of disease.
I am appearing for here.
Yes. What are your grounds, Mr. Sinha?
My ground is that fact of this case is that the deceased was, as per the claimants, is the driver of the tractor. Now the tractor was parked outside his house, and the engine mallet, despite
That was the wrong because my lord.
The vehicle and the vehicle.
Yes, and vehicle ran over him.
So,
started from a.
So your case is that Ashalada Bhome.
Yes, my case is that no person can be given my lord's compensation for his own mistake. Yes.
Own mistake.
Yes.
Own mistake. Yes.
And in this case, there is an FIR, and my lords, if kindly come to the running
What
page.
was his own mistake? What was his own mistake?
My lords, he was not supposed to try to override the natural power line of the tractor and should try to start the engine by bypassing some wires and attaching and giving spark to that. He was not supposed to do that.
This is your only ground.
But there are other grounds also.
What are other grounds?
And it's first of all the so far as my first ground is concerned, whereas there are two exhibits. Exhibit 2 is the charge sheet.
Yes.
Which says that the accident occurred due to own fault of the deceased.
No. Charge sheet is what is there in the evidence. Charge sheet is not
and Exhibit 11 is the report of the IO which shows that deceased himself was responsible for the accident.
What was the responsibility? The IO. What was
Well,
the
it's
responsibility?
my first case is they have preferred claim application under section 166 of IPA. It's not
Yes.
a case under section 163A.
Not a case under 163A.
So, pilots, whenever the case is under section 166,
Yes.
the negligence has to be proved. Now, my lord, somebody will try to play with the machine and will, for his own negligence, the death was
Yeah,
caused.
show me what is the negligence.
But it's
What do you,
negligence, my
what
lord.
do you mean by negligence? Just doing a particular act doesn't mean that he is negligent.
Negligence means that he was not supposed to do that particular thing.
Show me that he was not supposed to.
But nobody is supposed to bypass the self of the particular vehicle and try to start the vehicle coming in front of the vehicle and then trying to attach the engines directly with the battery. What is the manner of accident? But suppose my car is stopped. If he was trying to get the car start with self, then it's okay. If he has opened the bonnet, then also it's okay. And if the car naturally runs on him, on the person, then also it's okay. But if the vehicle is not getting start, somebody will try to come up with a battery, stand in front of the vehicle, and then put the wires to the engine so that the engine will start automatically.
So engine
And
started
it was,
automatically. What happened?
yes,
Engine started automatically.
when he put wires along with battery which was brought by him to the vehicle while he was standing in front of the vehicle, and the
What happened?
vehicle was in gear. So the moment he started, the vehicle rest on him. So this is the manner of accident. This is the manner of accident in this case.
I'll dictate the order tomorrow. Keep it tomorrow. Hard in part tomorrow.
That's two of the citations I have to.
It will be easier for you to go to the Supreme Court because you have your resource. You have resources.
Minutes.
Go and test it. Go and test it. Tomorrow.